We go ahead and get started. Okay, well, welcome everyone. Thank you for joining us tonight. I'm Yvonne Schwab, ACG Silicon Valley CEO, and most of you already know ACGSV is the leading business-to-business networking organization in Silicon Valley, providing connections, thought leadership, and enabling personal and organizational growth. ACGSV offers an array of networking opportunities with almost 15,000 members in 59 chapters across the world. ACG provides local connections with a global reach. We are offering a variety of virtual events in the coming months. We invite you to visit our website, acgsv.org, to see the full calendar, including discussions on SPACs, AI screening solutions, and cybersecurity, as well as several fun networking events with other ACG chapters and a virtual wine tasting at the end of September. If you have any questions regarding ACG Silicon Valley, I'm happy to have a one-on-one conversation with you and discuss your possible involvement with our 36-year-old chapter in detail. My door is always open for you. Now, we're thrilled to offer you today's event, which would not have been possible without our sponsor, the international law firm of Bird & Bird, so thank you. To continue the discussion, you will receive an invitation to join our LinkedIn group, which we created for all participants. Now let's get started. First, I would like to introduce you to Kai Westerwelle, panelist and moderator for today's event. Kai is a partner with Bird & Bird, based in its San Francisco representative office. He's a German certified specialist attorney for information technology with more than 25 years of experience in Germany and the US, advising international companies on German, European, and international data protection law. Kai is a regular speaker at national and international conferences and lectures data privacy at universities in Germany and the US. He's the chair of the Special Interest Group Data of the German American Business Association and a member of the Board of Advisors of the International Privacy and Security Forum in Washington, D.C. Let's also not forget that he is a member of the executive board of ACG Silicon Valley. So without further ado, I will hand it over to Kai, who will introduce our panelists today. Kai?
Yes, thank you very much, Yvonne, for the introduction and the invitation to speak at the ACG Silicon Valley. First of all, I shared my screen. Do you see the first page of the presentation, Europe Closes insofar?
Yes.
We're all good? Fantastic, thank you. I just want to make sure that we are sharing the presentation. Yeah, it's an honor to host this panel and certainly to serve on the board of the ACGSV. Thank you, Yvonne. We have a great audience today. Thank you for participating in this ACG Silicon Valley event on interesting enough data privacy. And I promise the title, Closing the Door, it really mirrors what happened 3 weeks ago. And it has and will have a substantial impact on your international business. So I have to get this done now, which is a bit complicated. Here you go. Now it works. I'd like to introduce the panel today. It's a great honor for me to have this panel for you today. First of all, we have Lydia de la Torre. Lydia is an off-counsel at the international law firm of Squire Patton Box. She is dual qualified in Spain and California and specializes on privacy and cybersecurity. Lydia is the owner and editor of Golden Data, a medium blog around data laws, and a member of the Antitrust and Privacy Section Committee of the California Lawyers Association. She lectures privacy at Santa Clara University School of Law, and she also provides for in-house experience as data protection counsel at PayPal in her past. Thank you very much, Lydia, for being on our today's panel. We also have Alyssa Bergman on the panel. It's my great honor. Alyssa is Vice President and Chief Privacy Officer of Adobe. She currently leads Adobe's Privacy, Trust, and Safety team. Prior to joining Adobe, Alyssa was the CPO, the Chief Privacy Officer at Warner Brothers, Time Warner, which is now Warner Media. Before that, she was a partner in leading privacy practices at law firms in Washington, D.C., and in Brussels. She's got great expertise in advising international companies on privacy matters, in-house as well as outside counsel. And she has helpful things, practical things to add, as I know her from previous panels. Sorry. Thank you, Alyssa, for joining us today on this presentation. Last but certainly not least, we have Lara Blissner on the panel. Lara is a senior counsel, data protection privacy at ARM. ARM is a UK-based international semiconductor and software design company and the world's leading technology provider for silicon IP. She has previously held positions at Google, Department of Homeland Security, Accenture, and the World Bank. Lara's expertise in data protection and privacy, cybersecurity, and in compliance. She's a regular speaker on blockchain, US and EU data protection, and global trends. Lara, thank you for joining me again on this panel. It's great to have you on board. We have some housekeeping rules. Questions are very welcome. So all participants, as you might have seen, except the speakers, should now be automatically muted. Please click on the chat button and on the right window and enter your questions and send it to the panelists if you want to, or you just raise your hands and you will be unmuted. The session will be recorded and the recordings will be posted. If we experience any technical difficulties, which can happen these days, you know, on all these video things, please bear with us. We try to fix everything and make it happen again. We are unfortunately not all together today in one room, but hopefully soon again, we have the chance to be together. The agenda for today, first of all, I'd like to give you some background on the transfer of EU data to the US. We have then the safe harbor and privacy shield invalidation, and then a lot of other topics like guidelines, reactions in the US, very importantly, what immediate actions you might want to take. And at the very end, we have a couple of discussion points. Let me give you, first of all, a little overview on the legal background on transfer for personal data from the EU to the US. As you might know, Europe seems to be a safe haven, or at least thinks of itself as being a safe haven when it comes to privacy. Europe, everything in privacy in Europe seems to be aligned, should be aligned due to GDPR, so you can transfer data within the European Union wherever and whenever you want if they were personal data. However, if these data are leaving the European Union, we've got a problem, because generally it's not allowed to transfer data, personal data from the EU to other countries, except where is a so-called adequacy decision. The European Union has decided for a couple of countries to provide an adequate level of privacy so that you can transfer data to these countries. If there is no such thing like an adequacy decision or other countries, there is a no-go. You cannot just transfer personal data to other countries, except there is a special reason for that. The US falls somewhere in between. It's a no country. It doesn't have an adequacy decision, but there are certain means that helped in the past. And that's about today's topic, actually. If you want to transfer personal data from the European Union to other countries, there are 4 options that you have to base it on. The one, of course, is the consent. So if the data subject agrees, you can always transfer the data out of the European Union. Also, there are so-called standard contractual clauses, which is an agreement between 2 parties. I come to that later. And the binding corporate rules, as well as the so-called safe harbor in former times. Consent is pretty easy. Consent is the agreement of the individual, the so-called data subject, to transfer the data out of the European Union. The subject has to be fully informed, which sounds easy, but it's not that easy. It's can be kind of complicated because it has to contain all the information, whatever you do with these data. It has to be freely given, the consent, and it can be withdrawn at any time, which is a problem. Think of all the data subjects who withdraw their consent once they've given it, but you base the data transfer of it. So it's an easy setup solution, but it has, of course, difficulties because it's an individual solution. The other option, binding corporate rules. Not to discuss so much today because it's pretty complicated. It actually is an agreement between all the companies in like a group company or with suppliers and all the things, and everybody in this group obliges its company to comply with European privacy rules. That's about the binding corporate rules. Very effective mean. It's expensive, unfortunately, and it's difficult to set up. However, it needs the approval of the data protection authorities in Europe. So that's, again, makes it a bit more complicated. On the other hand, of course, a bit more safe because you get the approved binding corporate rules. Now we come to the US. One of the most important basics of trade data transfers to the US are the standard contractual clauses. What is that? The standard contractual clauses is a basic agreement that is provided for by the European Union. It's a form you can download, and it's concluded between the European data exporter and the US data importer. So you base your data transfer to your importer in the US on these standard contractual clauses. And they actually are an addendum to every kind of processing agreement, to any kind of supply agreement and everything, where the US company obliges itself to comply with the European privacy rules. That's the standard contractual clauses. Again, it's somehow easy to set up to get these rules in place as the rules, and you don't need an approval from the data protection authorities in Europe, so it's fast and it's cheap. By the way, it's not negotiable, so you cannot add something on it, but often you find liability clause in all these things, which you don't have to sign, by the way. Last but not least, we had the so-called safe harbor. I said we had. That was the first agreement between the European Union and the US in 2000, according to which data could be transferred to the US to every company who has signed up with the safe harbor agreement. So that's kind of an adequacy decision. Now the companies in the US who signed up for the safe harbor are deemed to be safe recipients of privacy data, private data, and you can transfer them. This was of the highest importance for US companies. It was easy to set up, it was a fast solution, and it became the standard actually for data transfers from the EU to the US. It's US only. It doesn't apply to any other country in the world. However, unfortunately, we have this invalidation. In 2015, the European Court of Justice decided that the safe harbor is no longer valid. The safe harbor, so-called Schrems I decision, and Schrems is the guy who initiated these court proceedings in 2012, sorry. In 2015, the European Court of Justice said, well, he's right. Data transfers to the US based on the privacy shield, sorry, on the safe harbor, are no longer allowed. The reason for that was, US authorities can access those personal data, in particular US intelligence services, anytime. And there might not even be a supervision for that, so nobody controls them. And there's no real legal means for European data subjects to follow up with their rights in the US. There was no direct claim. And that's the reason why these clauses have been eliminated. Sorry, the safe harbor has been invalidated. That was an important step, and I want to break here and ask our great audience, Alyssa. Adobe is a major international service provider. You have many customers, B2C customers, B2B customers in the EU, in Europe, all over the place. You were not with Adobe when Schrems I happened, but can you not tell us, what were your thoughts when Schrems I happened, when all of a sudden a data transfer to the US became very difficult? How did Adobe set up? I mean, how long did the project take to get around all these things? Can you give us a little bit of background on what you experienced these days, 2015?
Yeah, sure. I will travel back in time to 2015 to take you to the thinking then. Many companies, including my prior company and other US companies, relied heavily on the safe harbor at the time because it was a very flexible mechanism and it was actually very commercial and business focused. And unlike the standard contractual clauses, which we'll talk more about, it didn't require like heavy deal cycles, and there was a lot of paperwork, candidly, with your vendors, et cetera. So the safe harbor, it took a lot of work and rigor to get into the safe harbor, because American companies take their commitments very seriously, and they wouldn't raise their hand and put themselves on the Department of Commerce website to say that they sign up to these principles, knowing that they'd be giving the Federal Trade Commission authority to come after them and hold them good on their promises. So it was a lot of work to put a company into the safe harbor, but it was a very good commercial mechanism. So upon the invalidation, it was actually quite a big deal, because there wasn't sort of a backstop or another mechanism that you could rely on for systematic transfer. So 2015 was a bigger impact on everything than what you'll talk about this time, because that was Schrems I.
Thank you. That was Schrems I, as you said, and now comes Schrems II. After Schrems I happened, the safe harbor agreement on 2015 was out. You couldn't use it anymore. It was now replaced by the so-called privacy shield. And the privacy shield was actually about the same as the safe harbor agreement, except it addressed the topics that the European Court thought about the safe harbor was not correct. A, there was no supervision, so they created the ombudsman thing. And B, there were no direct claims from the European Union to the US, and this should also have happened. So that replaced the safe harbor, and everything was right until 3 weeks ago. 3 weeks ago, Schrems II happened. Again, Mr. Schrems, same person, initiated claims against this shield, and he won in the very end with the European Court of Justice on July 16th. And again, we found ourselves in a position where this kind of standard basis for data transfer to the US was invalidated. And that was a big deal, of course. Now we went out of it again. And the reason for this was interesting enough. Again, it says US law does not set out limitations on powers of intelligence services, and there were no effective rights for individuals. Even though the European Court says, well, every country has the right to protect itself, so intelligence must happen, but you have some limitations. And they didn't see these limitations, so they held this this privacy shield invalid again, which of course creates a very difficult situation. This privacy shield had been signed by 5,378 companies in the US. So it was the basis for all these companies to transfer the data to the US. It's now gone, which leaves the standard clauses as the second most important alternative. But the court says as well, there's a lot of obligations you have to comply with if you use the standard contractual clauses, besides what the clauses itself says. And that's pretty important. The supervisory authorities now obliges data exporters in the EU to make sure that the data importer in the US complies with the rules. These are heavy burdens, in particular when you look at these obligations. That means the data exporter should now make sure that the data importer in the US is compliant, which means actually that the data importer in the US can make sure that no intelligence service is looking at the data, example given, right? But if they are still transferring the data, the European data exporter has to stop exporting them. You see from this slide, there are lots of obligations the data exporter might not even be able to comply with. So that's a big problem right now for this alternative, the standard contractual clauses. Coming back to the panel here, Lydia, Schrems II, related question to you. You are in the US and in the EU. You're a privacy specialist in Spanish and a US qualified lawyer. You're wearing both hats. What were your reaction when Schrems II happened? Can you give me an impression on that? Lydia, are you there? I think we lost Lydia somehow.
Oh, she's muted. She's muted.
She's muted. Lydia, you should unmute yourself, sorry.
Okay, how about now? Can you hear me now?
Yeah, that's perfect, thank you.
Okay, apologies about that. Technology gets in the way. So I will say that a lot of people like me with deep European backgrounds were very much predicting that we will see the outcome that we have seen for Privacy Shield. And so that the underlying issues that were raised in Schrems I were not necessarily resolved. And we just saw the court basically saying the same thing twice. So in a way, it was predictable, but it is a situation that causes a lot of uncertainty for organizations that are trying to do the right thing when they export data. And in terms of what you said, which is kind of this US-EU side, the one thing that I think I wish Europeans would understand, and they don't quite understand necessarily, is that there are limitations on the powers of surveillance that exist under US law. And they typically are brushed aside, and you see a lot of the conversation in Europe, basically stating that there is no reasonable limit in place. And that's not quite the case. I mean, you can make the argument that the limitations are not sufficient from a European perspective. I guess that's what the court finally decided. One of the challenges, though, is that the limitations that we impose in the US are not necessarily embedded in the act, in the law itself. They might be through executive order, and European courts are very reluctant to see that as sufficient. We had a similar case a few months ago in Spain, where Spain is, the Spanish implementation of the GDPR exempted the political parties, politicians, from the applicability of GDPR, and that was something that was brought up to the courts in Spain, and the reasoning of the Spanish Supreme Court was fairly similar to what we have seen in Schrems I and Schrems II, where they said, if you're going to limit the right, you have to embed some form of security around that limitation, and if it's not in the law, we just are going to strike it down. So it's very European thinking, and it's not necessarily the way we enact laws in the US, which is going to be pretty much a perpetual challenge for this situation with surveillance. The one thing that I think my US colleagues and the practitioners in privacy perhaps need to accept is that European has this right to data protection, and it's an old one. It's it started in the 70s, and fundamentally the setup is that if you're a controller, you're responsible for the data. So the general rule is always going to be that whatever happens to the data that might affect the rights of the data subject, you, controller, have an underlying obligation to solve for that, which is basically what we are now absent Privacy Shield. So we're kind of back to the default situation that we were able to, in a way, avoid through the adequacy decision that we have with Privacy Shield. And it's not a rule in European law that's going to go away. It's embedded in GDPR. It was embedded in the directive. It's just part of the doctrine of the European Court of Justice. So it's not an easily resolvable situation. The conflict is, I think, in a way, permanent.
Thank you, Lydia. I want to bring Lara in here. Lara, your company is UK-based. You're a US privacy specialist, exactly. So what Lydia said, you're living in between both worlds when it comes to privacy. What were your thoughts, I mean, from the UK perspective and from the US perspective when that happened?
Yeah, I mean, I wasn't, yeah, so I wasn't surprised at all by the decision. But unfortunately, sitting in the US and the number of data transfers that occur, not just among the US, but how this impacts transfers to other countries that are not deemed adequate, right? I mean, while the US was called out, there are other jurisdictions that would have similar issues. So it impacts business globally. So I was looking at it from that point of view. Unfortunately, the world just doesn't stop on a dime, and data transfers don't stop. So in the meantime, you're left to understand the situation, what it means for your business, and primarily we operate as a processor of information. So we're going to be on the receiving end of what controllers try and ferret out from the tea leaves that are available right now, given the fact that the European Data Protection Board and the Commission have yet to give any practical guidance, right? So, looking at it from that point of view, what can we start doing now to give comfort around that? So it's interesting to see that we are a UK company. And we're kind of, in that weird zone of Brexit happening. And what happens to transfers to the UK, by the way, after Brexit, given the fact that they probably have similar issues in their surveillance capability. So there are a myriad of issues going on around this, and we're looking at not only standard contractual clauses, but we also have a BCR application in flight. So looking at all of those things, how to adjust. So you have the understandable idea that in Europe this is a fundamental right, balanced against the pragmatic decisions that happen every day in a business, and the world just doesn't operate in the manner of which the decision comes down. So, yeah.
You raised a fair point, Lara. What you're waiting for is guidelines, right? Guidelines, everybody was waiting for guidelines from the regulators because this decision is there, but it's the court decision. It's not the decision of the regulators who in the very end enforce whatever happens. And after this decision, I just put it on a slide here, you get a lot of reactions from the European privacy authorities. They were all like, we appreciate it, it's all good, it's all right. However, some of them, and I have to apologize, again, the Germans, which are, when it comes to privacy, sometimes a bit more complicated, they were like, this wasn't even going far enough, right? Berlin said immediately after, this is the time for transferring your data processing capacities to Europe, to open up European data centers, which actually was definitely not the intention of this decision, right? Everybody else was kind of waiting for what happens in the future, and is there any more guidelines, how we can deal with this situation. And then we had, of course, a statement of the EDPB. This is the European Data Protection Board, which is the come together of all European privacy authorities, of the lead European privacy authorities. And they gave a little bit of insights of what they thought about the decision. It wasn't good, actually, because they first of all said, of course, Privacy Shield is gone. That was clear. They also said, fine with these obligations that we lined out, right, for the standard contractual clauses. So the data exporter is now responsible for a compliance in the importing country. But now they said again, well, the binding corporate rules, they're based on the same principle. Whether an intelligence looks into data is indifferent whether you look at standard contractual clauses, Privacy Shield, or binding corporate rules. So even there, it should apply. The only measure that was easy was the consent here. So that's kind of a very difficult situation, which I think impacts the entire international business when it comes to data transfer between the EU and the US. And Alyssa, I wanted to ask you on that. As you could see, there are so many European authorities thinking differently. And I mean, GDPR was the idea of bringing everything together, right? Having a one-stop shop approach. And now with these decisions, it looks like now the local authorities have now to decide whether or not the target country, here the US or other countries, are compliant with the European requirements on a local basis. How can that ever work? Are we going into the patchwork situation here again?
Well, hopefully not. To your point, I think that was one of the value propositions of a law like the General Data Protection Regulation, which was sort of common market and one Europe, and that was the goal. And as some of you on the call may know, and obviously as you know, that has been one of the areas of opportunity, frankly, for GDPR going forward, is to have more harmonization and consistency and interpretation generally. So this is not a particularly new issue, but it's definitely an issue that I know that the Commission and everyone is aware of in terms of those differences, but nonetheless a complicated issue to look at. I think as we were seeing different regulatory guidance, it was helpful that the EDPB came out, the European Data Protection Board came out with where they did. And then I think we saw more movement to kind of follow that. As you well know, that really is a consensus-driven opinion, and it has got representation from each of the data protection authorities. So that's been helpful. But to your point, the person who has to make the decision is the data exporter, and they might look to their own regulator. So for example, if we had customers in Germany, they may look to the German guidance, which could or couldn't be different. But I've seen more movement to really adopt that approach, which seems reasonable.
But yeah, thank you, Alyssa. I mean, for a company like yours, right, acting worldwide, it is an issue now, right?
Yeah.
Once again, you have to look in each country in Europe and check what the data privacy authorities are thinking there with respect to adequate countries, right? On a per country basis. Isn't that, I mean, I personally think this is against the idea of GDPR. It's against of the harmonization idea, but that's what it is. Lara, you raised one point which I think is amazing. You were talking about Brexit. And I want to look into that a little bit further. After Brexit, the UK will not be the EU. So theoretically, and also actually, I think practically, the EU will have to have some kind of agreement with the European Union to transfer the data. There is no safe harbor, there's no privacy shield. Do you think there can be an agreement, or will the same rules apply as for the US?
That's a good question. I actually think that the UK would prefer to get an adequacy determination. And in doing that, it will forego any type of, you know, UK, US privacy shield, you know, just to be more in line with data transfers from the EU. So yeah, I actually think that's the way it'll go, is an adequacy determination.
I hope you're right. Yeah.
Well, I hope too, but
I think,
you know.
It's interesting because we also see, of course, the idea between the UK and the US now having an agreement in place as well. So there's an easier data transfer from the UK to the US. So there are parallel streams right now that we see, and that could be difficult. By the way, I can't see the chat function here. So if anybody has questions, please bring it in the chat. And then Yvonne or Carol, if you could read them to me or give us, that would be great. I can't see them on my screen right now. Let's move on a little bit here, if we can. Yeah, we can. One thing I think is important, and Lydia, this one is going to you, of course, as the US attorney here on the panel. The reaction in the US was pretty, I think, let's say, encouraging. They were saying we're still talking to the European Union, as the European Union said itself. So we are talking about what can we do out of this situation and what will be the next step. So will there be Privacy Shield 3 or something? It's important, as we said, like the 5,500 companies are relying upon that data transfer on the Privacy Shield, and they can't do it anymore. What I actually found very surprising, and I would love you to explain this a little bit better to us, is that they say, well, actually, even though the Privacy Shield has been invalidated, all companies that have signed up for the Privacy Shield still have to comply with it. And I think that's a very interesting topic. Even though they cannot rely upon the shield to transfer the data to the US, they still have to comply with this, as you can see from this website from the US Department of Commerce. And by the way, other companies in the US, the big guys, they say, well, we're still using the standard contractual clauses, but the privacy shield is gone, but you still have to comply with it. Lydia, can you help me understanding why is that?
Can you hear me? Because
I can hear you well. No, that's perfect. Thank you.
Yeah, that's okay. So that's really interesting. But let's backtrack for a second here. So the privacy shield had two sides. One is the European side. From the European perspective, this was an adequacy decision. And an adequacy decision is not an international treaty. It's not an agreement. It's a unilateral decision by the European Commission that determines that a particular jurisdiction, in this case was not the whole jurisdiction, it was a particular program, meets the requirements to relieve the controller from their obligation to ensure that the data will be protected, because fundamentally that jurisdiction is so similar to the European Union that the exporter has to treat the data export as if basically there was no export, as if the data was to stay in the European Union. So that is what went away through Schrems II. Schrems II, basically the European Court of Justice, so the equivalent of the White House in Europe, that their determination was done incorrectly and therefore the adequacy decision is gone. There is a whole US side to Privacy Shield that is part of the structure of what companies sign up for, and that is based fundamentally in the FTC Act. So when you sign for Privacy Shield, you're basically making commitments that under US law are enforceable because you made those commitments publicly, which means the Federal Trade Commission has the ability to make sure that you uphold those commitments. So this side, the US side, was not really affected by the European Court of Justice decision, and therefore the US Department of Commerce took the position that is still valid. It's very, very, very frustrating for organizations that are not only dealing with their now need to put in place some other framework for their European exports, but also figure out how to get out of Privacy Shield, because at this point it's basically obligation without any benefit. So a couple of very practical points. Number one, any public statement that your website might have or that is in any other manner available to the public that states that you are transferring under Privacy Shield and that transfer is legal under European law has to immediately go, because that's not correct anymore. So if you were saying, I base my transfers on the Privacy Shield and that's a lawful manner of exporting data from Europe, you have to rephrase that as soon as possible, because otherwise you're basically misstating the current situation. So that's the pragmatic point number one. The other pragmatic point is what you cannot do is you cannot just, erase all of the information that you have on the Privacy Shield from your website and pretend that you never sign up, because there's a whole process that you have to follow with the Department.
Lydia, I think you're breaking up a little bit.
Oh, apologies about that. Is it better now?
Yeah, it's much better. Thank you.
Okay, no problem. So I guess I was coming to the end of my answer, which is from a very pragmatic point of view. If you sign for the Privacy Shield, you have to go through a whole process to get out of the Privacy Shield and have to figure out what happens to the data that you transfer while the Privacy Shield was valid from a US perspective, whether you have to apply those Privacy Shield principles on that data because you made the commitment before the US authorities. But immediately what you need to do is review your public statements and make sure that there's no statement that is saying that you're using the Privacy Shield as a legal way of transferring data out of the US.
Yeah, thank you, Lydia. You said one thing which I totally endorse. It's an interesting situation. You cannot benefit from the Privacy Shield because you cannot use it as a basis for the transfer of the data, but you still have to comply with it and take the obligations, right? It's an interesting aspect. I mean, one thing is important, the difference in Schrems I and Schrems II, Alyssa, that's more a new question for you. I mean, Schrems I had at least 3 months. Right, we had this period, the grace period, and within 3 months, Europe and the US could negotiate on a replacement. The Schrems II doesn't even have these 3 months. So from the very second, July 16th on, the Privacy Shield could not be used anymore, even though now I think the US, possibly, hopefully, the US and Europe are negotiating on Privacy Shield 3.0 or something. You can't rely upon it and you cannot wait. But coming to that, do you think there will be a Privacy Shield 3.0, Alyssa?
Oh, that's a, I have a magic privacy crystal ball to look into. No, at some level, I try to be optimistic about it because I do think that it's such an important trade issue. So I'm hopeful that something can be negotiated and that a resolution could come to. And I was encouraged by the announcement that you had on the screen the other day that these discussions continue. That said, we are in a pandemic. We are in a political year. There's these are hard things to actually do. I think the even though you know, there was an ability to move from the safe harbor to the privacy shield, the European Court of Justice was pretty clear about how important privacy as a fundamental right is and the challenges of overcoming some of the issues. Some of the issues are things that would require changes in US law, which again would be very difficult to do on such a short time frame. So I try to remain optimistic, but given the geopolitical world that we live in and some of the real challenges to have this happen, it seems harder. I did want to add, if it's okay, to the points that Lydia made on the importance of the privacy shield going forward and just generally some additional practice points. One is that this was and you can correct me if there's been more developments, Kai, that I've missed, but you know, this was the EU-US privacy shield. We haven't heard, there's also a Swiss privacy shield, so that still remains in effect. So one thing to consider is that, and waiting to see what the Swiss say if they follow suit. So that's one. Following also, to your point, what happens with the UK when Brexit happens, and is there some value for something like the Privacy Shield? Another thing I know that we've looked at both on using our own vendors and as a vendor to other people is a lot of times your contracts have said that you'll stay in the Privacy Shield. So before pulling out, in addition to doing the things that Lydia talked about and making sure that you file the appropriate paperwork with the Department of Commerce if you're going to do it and consider it, consider your agreements both with your vendors and with your customers. And then finally, maybe you'll get to this too, there is a lot of value at some level still to the Privacy Shield in that it shows that US companies take their commitments seriously. And as we look at what are the plus factors and what are the additional technical and organizational measures that companies can put in place on top of using the standard contractual clauses, this may be just one piece of the puzzle in kind of showing your the controls frameworks you have in place and just your commitment to EU privacy. So I just thought I would add those.
No, thank you. That's great. I mean, that leads actually to the idea what you have to do right now. What can we do, right? Immediate actions and midterm fixes and long-term solutions, if there are any. Just let me walk through this for just a second. I mean, first of all, I think the most important thing from my perspective, and please everybody correct me if I'm wrong, but I think stay tuned. Right, it's the most important thing. Things are developing right now. Check for the guidance out there. We don't know what happens. It's developing on a weekly basis. And that's something I think is the most important thing. And also, I mean, think about, check your data transfers to the US. Make sure you did your due diligence. Make sure that you did your data mapping, that you know whether you are using the Privacy Shield or you're using standard contractual clauses and where. And what I think, and we see this already from the European perspective because a lot of our clients are now asking for, do you have a questionnaire to be sent to US companies so that I can make sure, you know, they are compliant? So you might see, if you're a US company and doing data processing for Europeans, you might be asked questions around security and all these things and data privacy. So that's pretty important. And Lydia, I think you said, well, continue to comply with the Privacy Shield if you sign it, right? Otherwise you're in breach and the FTC will go after you. I think that's a pretty important direct ideas. And next step, midterm, I don't know. Maybe you want to implement standard contractual clause if you are still relying on the Privacy Shield. I think that's a pretty good idea. Be prepared, there will be additional questions. And actually what we see from the EU right now is you might have standard contractual clauses and some add on individual clauses between, in particular, processor and controller, as a controller in Europe and processor in the US, and you will have that. And also they will ask for safeguards. Example given, transportation, is that encrypted and all these things? So I think that data security, technical safeguards become more important. Think of binding corporate rules. That's a nice idea, but actually, as I said, Alyssa, that takes a lot of time, and it will not be a solution for now. It's a long-term solution, and we don't know what will happen to these rules. That's pretty important. I would definitely think, check for Privacy Shield 3.0. Hope it happens. If so, you can subscribe. Otherwise, I think, as Lydia and Alyssa said, you might have to unsubscribe to these two things, because that could be important. That's at least my take on immediate actions that we have here. But we have one question which I want to share with the panel here. How are the cloud services providers, such as AWS, that use distributed servers dealing with EU restrictions? And the understanding for the question was, they're currently using SCCs, they're intended for controller processor. Can they also be used by processor to sub-processor? It's a very good question. I mean, first of all, from my perspective, AWS has distributed servers around the world, and like every other services, they might even offer local solutions because of these restrictions, example given in Germany. And there are standard contractual clauses, even from processor to sub-processor. But Lydia, Alyssa, who wants to jump in on that question? Have you an idea? Any comments on that?
Sure, I'm happy to jump in if you want.
Please do.
Sure. I mean, one of the things that we've done that other people have done as well too, and you're right, it's a challenging situation because we haven't gone into that. That would maybe be for another panel. But if you're to follow the data on all of the hops, kind of making sure that all of the hops are covered off. In a lot of instances, the Privacy Shield was a good way to cover off some of those hops where the contracts are either hard to put in place or the contracts don't anticipate those types of relationships, processor to sub-processor. But one of the things that we've done and other people have done is putting in place something called an intergroup agreement that has your European entity and your US entity in privity there too, and then giving some contracting abilities and rights to your US entity to enter into some of those contracts on behalf and work through some of those types of relationships and sort of flow down requirements. So it's sort of a complex legal theory, but we had done a lot of work with that when we mapped all of our data transfers, employee, vendor, consumer, and customer, and put together a larger framework about the relationship between our entities, and some of those flow down requirements are covered in agreements like that. So I offer that as a suggestion, but others may have other approaches that work, and feel free to comment on that, Kai.
Yeah.
This is Lydia, Kai. Thank you. And I think, I mean, I echo what Alyssa just said. And going to the practical steps that Kai outlined, I think they are all very important, but there is one that I will advise this particular audience to think about. And it's very simple. If you are dealing with European data and you're taking it outside of the European Union, it's likely because your business finds it more cost efficient. And you need to have a conversation with them that part of the savings has to be budgeted for compliance, because you might be saving, but you're also creating a heavier burden on Alicia and other data protection officers and chief privacy officers that are trying to deal with all of these complex rules that are coming online in Europe, and we see that in other countries. So I think that if you are in the position to be general counsel, one of the things that you have to educate the business about is that where you're saving money because you're maybe processing in a more efficient way, you maybe are using sub-processors in India, et cetera, there is a cost to it for the organization, and that should be accounted for and budgeted for.
Lara, your company is a lot of processing, right? You're a processor on a big part of the data. What do you think on that?
Yeah, I mean, so we also have sub-processors, right? So we have a long list of issues here. I think for us, I'm waiting to see when we get some indication from the data controllers that we work with on what their expectations are. And seeing, and it's just not sitting and waiting. I mean, we're actively thinking about, you know, the measures you listed: transparency, reports, tokenization, all of those things, right? And then of course, one of our big issues is sub-processors. We do have a number of them, and not all of them in the U.S. And they do go to jurisdictions that are, you know, not adequate, or in the process of becoming adequate, or you know, one of those areas. So there's a lot to consider, and it's not an easy fix. I think intercompany agreements is a great suggestion. You know, I think a fear of having too much of a patchwork and intergroup agreement is a great way to go. But yeah, it's not an easy time. Because the data strand, I mean, I don't think there's any company that just said, oh, we're going to stop transferring data, or, oh, we can immediately turn to data localization. So, you know, I think there are a lot of folks that the longer this goes on, the more nervous they become, because the risk increases, right?
Yeah, fully agreed. And I think, you know, you saw the comment from the Berlin Data Protection Authority saying, hey, you have to now have a local solution in Europe.
Mm-hmm.
Hopefully Berlin, I think that's what they're hoping for. That's definitely not the solution, because I mean, the one thing we shouldn't forget, and the question outlined that too under the AWS question, it's not only that you store the data on one location, right? It's also that you don't have access to this location from any other country. Because one thing I think from my perspective is very important. It's not only that we're not transferring data to the US, to the data centers in the US, even if you provide local data centers within the EU, who does the maintenance? Who has access to these data? And very often, at least, you know, step 2 or 3 maintenance is always done from somewhere outside of the European Union. And these maintenance people do have access to these data. And from a European GDPR perspective, again, that means a data transfer. It sounds a bit odd because no data are transferred. But if you're a US company and having customers in Europe, and you're serving all these customers, and you even have a local data center, even if you do that at AWS or whatever Google server in Berlin, still you might not have the capacities to maintain everything from there. So you have then to think about, do I have to build up European capacities, right? And I mean, one thing, Lara, that you brought up and that troubles me a lot is, I mean, that's not only the US. The Privacy Shield is the US, right? But we're talking about every other company outside of the EU, not only UK, unfortunately, pretty soon, but we're talking about data transfers to India. We're talking about all these countries where a lot of data processing is happening. And I think that's an important thing. So, Alyssa, I want to ask you, having said all these, what will be, or what are, I assume you have already taken your action items on this situation for Adobe. What did you do? What do you recommend the audience to do?
Yeah, I mean, I think I spoke a little bit about it, but let me give a good concrete list so people have good takeaways. So we looked at all of our data flows, because it's you know, all the different categories of personal data, which we look at as employee data, vendor data, direct to consumer data. We have consumers interact with us, and then enterprise customers data. So looking at each one of those, we looked at doing transfer impact assessments and looking for each of those work streams. Where are we a controller? Where are we a processor? Where were we relying on Privacy Shield? Where did we already have standard contractual clauses in place? What do we need to do in looking at all of those? to add to that plus? What are those other things that we can do with those standard contractual clauses through each of those various work streams? So we've done all of that. On top of that, it spun up a lot of work for our team and doing some of the things that Laura was talking about too, looking more holistically at our data center strategy for the future. To Laura's point, it's not something you can do quickly, but like looking at the architecture more broadly, thinking about where support services are, who accesses what, is there a role for either more encryption or more tokenization or virtual desktop interfaces or other ways that get you to those types of things. Looking at the types of data we have, that's another angle I think that people are looking at for these types of transfers and thinking, is this the kind of data, to your point, that's either subject to FISA and or is it sort of non-sensitive marketing data, and kind of looking sector by sector and coming up with a whole story. So it's really going work stream by work stream, doing transfer impact assessments, and then broadly taking a look at, again, thinking about like the developments that are happening in China and Hong Kong and with Brexit, localization potentially in India or whatever, and just taking a step back, having the legal piece be one piece of the broader data center strategy, looking at demand from customers, efficiencies, all of those other things, that tax issues. There's a lot of factors that go into a data center strategy, but recalibrating if this was an input and seeing the weight that it needs to get with the changes that are happening on these topics.
But actually, it sounds like you have a lot of action items here, right? I think that's very important. And you're a big company. Lydia, I want to ask you, I don't know whether you work with smaller companies too, but again, isn't that something that a big company can easier do than a small company? Because they might not have premises in Europe. Is that disadvantaging the US smaller business?
Right, that's a great question. So, I mean, we serve clients that are big companies and we serve clients that are fairly small companies, and they don't have the same level of resources. Sometimes they don't have the advantage of having an in-house expert in privacy, and that makes it more challenging for medium and small size organizations. I really think that one of the missed opportunities of GDPR was to set some form of baseline as to what organizations this applies, or at least set a different set of standards and obligations for organizations that don't meet certain thresholds. This is an issue across the board. This is an issue in Europe, even for data protection authorities, in terms of how they enforce GDPR, because it's so broad that they have to selectively, enforce it. Unfortunately, that's not the situation. So what we are trying to work with when we work with a small organization, sometimes is, basics. It's just getting the paperwork in place for every contract. Not everybody has that. It's not that easy. It sounds easy, but it is actually not that easy to implement. Yeah. And then the other issue that Kai raised before is that GDPR assumes that controllers have control, but for small organizations that actually use service providers that are large, and we were talking about AWS, but it applies across the board to many providers of technology that are big organizations. Medium and small companies do not have the bargaining power when it comes down to negotiating anything with organizations that are much larger than them, which also places them in a more difficult position in terms of ensuring their own compliance. So it's a different set of challenges that you just have to address at a different level.
Yeah, thank you. Lara, we are running out of time, but I don't want to stop before having heard your ideas. What's the next step for you? What did you do? What do you recommend as this is the action, and what do you expect?
Yeah, so we did much of the similar things, or are in the process of doing what Alyssa has said. So looking at our data flows, looking at transparency reports, tokenization, and then also looking at, does FISA actually apply to the data we're getting, right? Would it come into play there? So, what is our risk assessment and our obligation there?
Thank you. That's very helpful. We are out of time, but I don't want to stop here without thanking the panel. I hope everybody thought it was a very fruitful discussion. I thought it was great. And thank you so much, Lara, Alyssa, Lydia. I think it was a great discussion. I hope we all learned a lot of it. I think the one thing that we learned is, unfortunately, it's not getting any easier. Stay tuned, think of data, because I mean, we're in Silicon Valley, and Silicon Valley is kind of living out of data, a lot of it at least. And for every company doing business international with Europe, data are the backbone. Stay tuned. And if you have any more questions, approach any of us. You have our email addresses, and we will distribute the slides after this presentation. And there will be recording to be provided by Yvonne. Yvonne, thank you so much. Over to you.
Thank you, everyone, for joining us tonight. Thank you, Kai, and everyone else on the panel. Beautiful discussion. I think that everybody took at least a bit of information home tonight and is a little better versed on this. So check out acgsv.org for more events coming up, and we will see you soon. Thank you so much for spending your evening with us.
Thank you.
Thank you, everybody.